In the Seven Fires prophecy, the origin story of the Anishinaabe people, the Ojibwe were told to travel west from their traditional home until they reached the place where food grows on water. That place was the river and wetland country of the northern Great Lakes, and that food was wild rice, or Manoomin, the most important cultural and sacred food of the Chippewa, Ojibwe, and Anishinaabe peoples. This is the only place in the world where Manoomin grows wild on the water. Centuries later, this same land is dispossessed and colonized by the United States and Canada. The climate is heating up at a dangerous rate. The multinational fossil fuel transport company, Enbridge Corporation, is running a pipeline to carry tar sands oil across Minnesota, and the first ever Rights of Nature lawsuit in tribal court is filed against the Minnesota Department of Natural Resources for allowing it to happen. The plaintiff of the lawsuit is Manoomin itself. This is the beginning of its story. Manoomin versus Minnesota Department of Natural Resources is the first Rights of Nature case in the U.S. to occur in tribal court, and also the first to have a plant as plaintiff. But it is part of a larger Rights of Nature movement for a society-wide paradigm shift as well, calling on people to reimagine how we think of the plants, animals, and earth around us. The argument is that nature itself has rights to exist and flourish that we, as people, must protect, instead of treating other organisms as property or resources to be expended. Some may consider this integration of nature into legal theory to be radical and a completely new way of thinking about justice in relation to conservation. But to others, including many indigenous perspectives, this is an understanding which is ancient tradition and integral to our relationships with all other parts of the environments we live in. The first ever Rights of Nature case in the U.S. was filed on April 26, 2021 in Orange County, Florida. In November 2020, 89% of Orange County voters voted in favor of the waterways of their county deserving recognized legal rights. It is the largest municipality in the U.S. to adopt Rights of Nature law. The law which passed secured the waterways' rights to protection against pollution and the right to a maintained healthy environment. It also recognized citizens' authority to file enforcement actions in the name of the waterways and for courts to see to it that projects and activities do not violate these rights. The case of Wild Cypress Branch et al. Versus Beachline South Residential, LLC and Noah Valenstein, Secretary of the Florida Department of Environmental Protection, was then filed to protect the waterways from a proposed housing and commercial development project which would destroy connected wetlands and streams. The housing development would require a development permit from the City of Orlando and a dredge and fill permit from the Florida Department of Environmental Protection in order to proceed. The suit seeks to block these permits from being issued. Manoomin has had its legal rights since even before the waterways of Florida, though. In December 2018, the White Earth Tribe, which, with 25,000 members, is the largest indigenous tribe in so-called Minnesota, adopted the rights of Manoomin, including the right to pure water and fresh habitat and a healthy climate. However, those rights are being threatened by a fossil fuel project that has sparked protests and demonstrations for months, even years, on end. Line 3. The Line 3 pipeline was built by the Lakehead Pipeline Company, now known as Enbridge, in the 1960s. Line 3 is responsible for the worst inland oil spill in U.S. history, a 1.7 million gallon crude oil spill into the Mississippi River, which happened near Grand Rapids, Minnesota in 1991. The spill led to the Enbridge Corporation cutting down the capacity of the pipeline to 390,000 barrels per day in 2008. But in 2015, Enbridge announced the proposal of the replacement and expansion to the pipeline, which would transport about 760,000 barrels of tar sands oil per day, bringing the capacity almost back to where it was when the spills occurred that devastated wetlands and other ecosystems across Minnesota. With the construction of both the Canadian and American segments of this pipeline now complete, the people who live along its path anticipate the day it will spill just as its former self did. The path of the Line 3 expansion passes between the lands of the Leech Lake, Red Lake, and White Earth reservations. Though it does not cross over reservation lands, it does cross over waters where the tribes have treaty rights to hunt, fish, and harvest wild rice. According to Article 5 of the Treaty of 1837, between the Chippewa or Ojibwe people and the United States, the Chippewa have the reserved right and privilege to hunt, fish, and gather the wild rice upon the lands, the rivers, and the lakes included in the territory ceded. Yet, the United States government, namely the Minnesota Department of Natural Resources, has failed to uphold and ensure that right. This is what the plaintiffs of the Manoomin case, including White Earth tribal citizens, indigenous and non-indigenous protesters against Line 3, alongside the wild rice, are accusing the Minnesota Department of Natural Resources for. By granting the Enbridge Line 3 project increased access to the pumping of approximately 5 billion gallons of public ground and surface water, and drilling under rivers and other waterways in the upper Mississippi watershed, without formal notice to tribal leaders and without Chippewa consent, the Department of Natural Resources is failing to protect Manoomin and the freshwater resources for the people who depend on them most. The wild rice is specifically in the treaty as a legal term, and it is being harmed by treaty laws not being followed. Therein lies its ability to be a plaintiff. The Manoomin case is not the only legal challenge coming up against Line 3. Pipeline opponents, including 2 Ojibwe bands and 3 environmental groups, filed a lawsuit in December 2020 to sue the U.S. Army Corps of Engineers for their part in the implementation of Line 3. The plaintiffs, known as Friends of the Headwaters, have asserted that the Corps failed to comply with the Clean Water Act, the National Environmental Policy Act, Corps regulations, and the Administrative Procedure Act. They also allege that the Corps did not consider the potential life cycle greenhouse gas emissions from putting the Line 3 oil pipeline into service, and the associated social cost of climate change. In early 2021, the plaintiffs asked the federal court for a summary judgment, which would mean that the factual issues are decided and that the case would not need to be tried in order for their calls to action to be enforced. However, the Corps also asked for a summary judgment, but with a different set of facts in its favor, countering the plaintiffs' allegations and saying that the Corps had met all of the permitting requirements under federal environmental law. The disagreement over facts here brings up another issue. How can we decide what is true justice for the environment if we cannot even agree on what is the truth? There are other philosophical and legal issues surrounding the Manoomin case as well. After the case was filed in White Earth Tribal Court, the Minnesota Department of Natural Resources filed a motion for an injunction against the tribal court and judge. The department asked that the U.S. federal court dismiss them from the case, as the defendants are not tribal citizens, and argued that the tribal court lacked jurisdiction over the state agency. But on September 3, 2021, the federal judge dismissed the motion, saying the Supreme Court lacked authority and jurisdiction to let the department free from the case. As Angelique Eaglewoman, professor and co-director of Native American Law and Sovereignty Institute at Mitchell Hamlin School of Law, said, "The federal court rightly noted that it has no authority whatsoever to enjoin a tribal court judge from hearing a tribal court law case. This is a matter of respect between different sovereigns, and is also a matter of U.S. Supreme Court decisions holding that tribes have sovereign immunity." The way that the Department of Natural Resources went to federal court to try to stop the case is a completely different course of action and way of thinking about these issues of justice than how the plaintiffs approach the same issues. Rather than seeing the rights of Manoomin lawsuit as an opportunity to discuss the claims and seek a settlement which would better the environment for all involved, they instead called into question the jurisdiction of the tribal court, conveying a dismissiveness and lack of willingness to communicate. Each of these questions of jurisdiction frames a larger question. Who gets to define justice? Is it the U.S. federal court system, which breaks its own treaties? Is it the Department of Natural Resources, which has a mandate to protect the wild rice? Is it the White Earth Tribal Court, which the department claims has no say in what happens outside of its lands? Is it the societal idea of a legal system overall? The economist and philosopher Amartya Sen tries to answer this question. Who owns the definition of justice? In his 2009 book, The Idea of Justice. Sen argues that a theory of justice is necessary to bridge the divides between what different groups of people deem as just. He says that people have a natural, intrinsic sense of what's right and wrong, but that our ways of enforcing justice rarely work together. This is because of our differences in cultures and values, and also because too many philosophers have tried and failed to create an unequivocal, all-encompassing definition of justice. In fact, says Sen, we need to recognize that justice is different for different people. True justice can never be achieved under one prescribed system. Looking at this case, a lot of what Sen says resonates. The concepts of justice under the U.S. colonial court system, in the boardrooms of Enbridge, and on the laminate floors of rural Minnesota county jails, and the ideas of justice in the White Earth tribal court, in the resistance camps, and in the rivers where Manoomin grows, all conflict deeply. But this case, if it goes through, has the chance to serve as a bridge from one concept of justice to another, and a chance to change the way the colonial legal system defines justice. The plaintiffs of the Manoomin case are calling on the state to stop the extreme water pumping and for authorities to stop arresting people for trying to defend codified rights. Over 700 people have been charged in demonstrations along the Line 3 construction route, while taking direct action to disrupt construction. Because of Line 3, there are even greater injustices surrounding this case, including the exacerbation of the impacts of climate change, police brutality carried out on protesters, corporate counterinsurgency, and the potential for poisoning the Mississippi headwaters, which account for approximately 1/3 of America's drinking water. Protesters have experienced rubber bullets, pepper bombs, Border Patrol helicopters flying over them as they sleep. They have stood witness to the constant drilling and surveillance as they stand with the land and river while it is still with us. On one's first night of the protest camps, as the drills went under the river, it was impossible to express the sense of injustice felt. Sen's words didn't seem to go far enough to describe the injustice of watching a river die. Right now, the Manoomin case waits in the 8th Minnesota Court of Appeals, where another judge will determine if the Department of Natural Resources does or does not fall under the jurisdiction of the White Earth Tribal Court. If the judge rules that it does, the case will proceed to White Earth, and Manoomin will have its say in court. This will be a paradigm shift for the idea of justice in the legal framework of the United States. Never before has this legal system granted a plant the ability to claim rights or to hold a government entity accountable. Until then, we wait for the ruling. We wait to see the effects of Line 3 on Manoomin. The line went operational on October 1st, 2021, pumping gallons of oil a day right under the rivers where Manoomin grows. Sen says that the best solution to defining justice is to become informed of other perspectives, and not to keep a closed-mind adherence to one idea of justice. Essentially, he leaves his biggest question, who owns the definition of justice, unanswered. All he says is we need to know the facts. Will this court case bring Manoomin the justice it deserves? Will any measure of human justice that our existing legal systems apply be enough? Or while Manoomin waits for its last few weeks of clean water before the next inevitable spill? We wait for the decision. We count the last grains of wild rice. We drink the water while it still flows clean.